Hello and welcome to this webinar on understanding manorial rights and profits of Prendre in modern conveyancing. My name is Anna Newport and I'm delighted to take you through this important and often misunderstood aspect of property law. As conveyancers, we frequently encounter historical rights that can complicate modern transactions. Some of these, like restrictive covenants, are well understood. But others like manorial rights and profits of Prendre often raise more questions than answers, and we don't deal with them routinely on a daily basis. So, you see something on a register and you worry. So, what are they? Why do they still exist? And what should we do when they appear? In this session, we're going to break down the rights, how they arise, and most importantly, how to deal with them effectively in practice. We're not looking at how to register them or put them on registers, but those things are still possible. Why this topic matters really is that manorial rights and profits are relics of a feudal system, the feudal England and the Welsh system, yet they remain embedded in property law today. They don't come up in every transaction, but when they do, they can delay transactions while buyers, lenders, solicitors try to understand their impacts. And they can raise mortgageability issues, so particularly where mineral rights are involved. Mineral rights causes immense amount of problems on development projects or and they can be quite a costly event. So whether that's separate mineral rights with a title or or rights of taking. They create barriers really to developments when third parties retain rights over the land. So the rights themselves were significantly affected by the Land Registration Act 2002, which removed them from the list of overriding interests unless they're formally registered before the 13th of October 2013. The big one we know about that is chancellery peril, although clearly that sits aside. But many of the manorial and profits remain enforceable because of that deadline. Others might have been extinguished. However, even when a right was not registered, traces of it can still appear in title deeds and historic documents, particularly when you're dealing with unregistered land, and they require careful investigation.